said report. I also request Honorable Kimani to second the motion of agreement with the report of the Committee of the Whole House. Thank you.
Majority Leader.
Honorable Speaker, I beg to second.
Very well. I therefore propose the question, which is that the House do agree with the committee in the said report. Do I put the question? I put the question that this House do agree with the committee in the said report. As many as are of that opinion say aye. As many as are of a contrary opinion say nay. The ayes have it. Mover to move that reading. Kathiani.
Yeah, Honorable Speaker, I beg to move that the Election Offences Amendment number 2 Bill, Senate Bill number 28 of 2024, be now read a third time. I also request the Honorable Majority Leader, Kimani Ichung'wah, to second.
Honorable Speaker, I beg to second. And Honorable Speaker, let me say, as I second, this bill is among the NADCO implementation bills that I co-chaired together with the party leader of Wiper, Honorable Mui, is now the Wiper Democratic Movement, Patriotic Front, and our former Vice President, Honorable Kalonzo Musyoka, who we co-chaired NADCO with. And these bills are very important in helping IEBC and our country to midwife the next general elections. And therefore, as I commend all those who were with us in NADCO, including Honorable Kalonzo Musyoka, Honorable Hassan Omar, Honorable Amina Mnyanzi, Honorable, no, I can't thank Eugene, he disappeared. Honorable Cecily Mbarire, the able Minister for Cabinet Secretary for Energy, Honorable Pio Wandai, Honorable Okongo Mugeni, Honorable Speaker, the Leader of the Senate, Majority Leader, Honorable Aaron Cheruyot, and of course the able leadership of President William Ruto and Prime Minister Raila Amolo Odinga. This bill now sets in place what the country has been speaking about, the implementation phase of the NADCO recommendations, Honorable Speaker. And I therefore commend the House and both houses actually for the passage of this bill, being, I think, the second or the third bill amongst the legislative proposals that came out of the NADCO process. The first being the reconstitution of IEBC under the amended act that we did last year, and we now have that IEBC in place. This law now goes to foster what was expected of that IEBC, and I do hope that the commission that's in place will get in motion to start preparing not just for the by-elections that are slated for later this year, but also prepare for the general election. I beg to second.
Honorable Chepkonga, you know I have to propose the question first. So allow me to propose the question, which is that the Election Offences Amendment number 2 Bill, Senate Bill number 28 of 2024, be now read a third time. Chepkonga.
Thank you, Honorable Speaker. It will be a travesty of justice if I don't say something, and I appeared before the very competent committee that was chaired by our majority leader together with the Wiper, not the Wiper Patriotic Front leader, the Honorable Kalonzo Musyoka. Madam Speaker, it is questionable. The patriotic one is questionable one. Maybe the front one we agree. But Madam Speaker, I must say that the public participation that was conducted by this committee, Madam Speaker, was quite extensive, was fruitful, and I must say that the proposals that came out of it, which you have just considered in the committee of the whole House, and now as we consider in the third reading, were very innovative and very progressive. In fact, it has come at a very timeless manner because of the constitution of IEBC. And these are very important provisions that will help us in ensuring that we conduct fair and transparent and accountable elections. So I support Madam Speaker.
Very well. There being no more interest on this, allow me to put the question that which is that the Election Offences Amendment number 2 bill, Senate Bill of number 28 of 2024, be now read a third time. As many as are of that opinion say aye. As many as are of a contrary opinion say nay. The ayes have it. Next order.
A bill for an act of
Okay, sorry,
Parliament
before the next
to
order.
amend the Elections Offences Act. Order number 10, motion, consideration of the Affordable Housing Regulations 2025.
Chair, delegated Honorable Chepkonga.
I thank you, Honorable Speaker. I beg to move that this House adopts the report of the Committee on Delegated Legislation on its consideration of the Affordable Housing Regulations 2025 laid on the table of the House on Tuesday, 12th August 2025, and pursuant to Section 59, subsection 4 of the Affordable Housing Act number 2 of 2024, this House approves the Affordable Housing Regulations published as legal notice number 114 of 2025. Madam Speaker, Article 43, subsection 1, clause B of the Constitution guarantees every person the right to accessible and adequate housing as well as reasonable standards of sanitation. In addition, Article 21 obligates the state to take legislative, policy, and other measures, including the setting of standards to achieve the progressive realization of the rights guaranteed under Article 43 of the Constitution. To give effect to Article 43(1)(b), Parliament enacted the Affordable Housing Act number 2 of 2024, which establishes a framework for the development and access to affordable and institutional housing and for connected purposes, which includes also, Madam Speaker, social housing and rural housing. We noticed, Madam Speaker, that there are constituencies that are very small, but with very huge populations. And one of it is represented by one of our members in the committee, the Honorable Watch, whose constituency is 4 by 4 square kilometers with a voting population of 130,000. And the area is too small, and the people that live there would not be able to afford affordable housing. So these regulations provides for social housing in place of affordable housing, so that we can be able to accommodate Article 43 of the Constitution. Section 4 of the Act imposes a housing levy at the rate of 1.5% of the gross salary of an employee or the gross income of a person that is not otherwise subject to the levy as gross salary. Under Section 5, employers are required, A, to deduct the levy from an employee's monthly salary. Number 2, they must contribute an equivalent amount as the employer's share. And number 3, they must remit the employees and the employer's contribution to the appointed authority and collector within 9 working days after the end of the month. The levy is intended to generate funds for the development and financing of affordable housing for Kenyans. Pursuant to Section 59 of the Affordable Housing Act, the Cabinet Secretary for Lands, Public Works and Housing and Urban Development has enacted regulations to facilitate the effective implementation of the Act and provide clarity on its application and implementation, Madam Speaker. Honorable Speaker, the Committee on Delegated Legislation considered this regulation in accordance with the Constitution, the Statutory Instruments Act, the Affordable Housing Act of 2024, and an interpretation of General Provisions Act, Cap 2. In compliance with Section 16 of the Statutory Instruments Act, the committee held a meeting with the State Department for Housing and Urban Development on Thursday, 7th August 2025. Madam Speaker, the salient features of these particular regulations are as follows, Madam Speaker. The regulations that have been made contain very important provisions, Madam Speaker, that seeks to resolve a number of issues that the Act itself has not provided for. Among them, Madam Speaker, the regulations provides for preliminary provisions, including the citation, interpretation of certain words that have been used that were not interpreted in the Act, Madam Speaker. Of importance, Part 2 of the regulations provides for the allocation of affordable housing units. As you know, Madam Speaker, there was a lot of doubt as to whether people would be interested in affordable housing. As you know, we've just seen what happened recently when the President launched the affordable housing, and the number of people who are interested. And we saw the people who are already entering into those houses. So there has been massive interest, Madam Speaker, and the Cabinet Secretary has therefore provided the criteria on allocation of these houses and why someone would be denied, and they will provide reasons. This part contains provision on eligibility criteria for allocation of an affordable housing unit, the procedure for allocation of an affordable housing unit, the procedure of the board to decline an application for an affordable housing unit that is not successful, the rate of deposit, which has been capped at 5% of the purchase price as provided under Regulation 7 of this